Okay, hello everybody, and welcome to this recording of the MIST lecture on military operations in the law of the sea. Apologies we didn't get to cover this in our seminar this week, but I'm sure you will agree that the seminar we had was so fascinating and we had so much to cover that it was a good thing we overran in a sense, and of course I could just record it and place it here. So what we were covering today is a bit about military operations and what this means in the context of the law of the sea. Now, of course, as with all the topics we've covered on this course, it's a huge topic in and of itself. You could do a lot of research in this whole area, and I, of course, will not be able to cover anything like the detail that's available in terms of the research out there. But instead, what I'd like to do is just give an overview of some of the interesting or important things that are pertinent to how military operations and military activities take place in the sea and some of the international legal issues surrounding those. So this will involve looking at what kind of peacetime military operations we're talking about, briefly what the law of naval warfare is, looking at sovereign immunity, and then particularly looking at what we call FON Ops or freedom of navigation operations, and how major states are resolving excessive maritime claims or seeking to resolve excessive maritime claims by displaying military power or rejecting other states' interpretations of the law of the sea. And of course, on the right hand side there, next week we'll be covering other topics. So, what are military operations? What are we talking about? Well, it might include things like maritime law enforcement, counter-drug operations, migrant interdiction, and other forms of security operations, counter-proliferation of terrorism, weapons of mass destruction, nuclear deterrence, things like that. Of course, espionage, surveillance, and so on. And of course, naval warfare, and then weapons testing and military exercises, and disaster relief and humanitarian assistance, and as I've mentioned, FON Ops and displays of military power. So, the first thing to note is that the Law of the Sea Convention and much of the existing customary law of the sea regards the ocean as being open to use exclusively for peaceful purposes. And this can be found in Article 301 of the Law of the Sea Convention, which does say that states should effectively refrain from using any threat of force, a threat or use of force against another state, except where it's consistent with international law. And that kind of falls within the general remit of international humanitarian law generally and the law of naval conflict and law of warfare. But the idea is, of course, that we should be avoiding any forms of aggression and use of threat, and rather using the ocean for peaceful purposes. But of course, where military activity borders on a use of threat or a use of force, that is obviously an open question. So this brings us on to the law of naval warfare. Now, I won't cover this. There are experts elsewhere, and particularly even at our university, which cover this topic. But the normal rules of warfare would apply to naval warfare, such as those regulating jus ad bellum, the law on the right to war, and jus in bello, the law in waging war, so the law that applies when you are in war, and all other rules of international humanitarian law. So therefore, the sort of usual sort of agreements and accords, such as the UN Charter and the Hague Treaties resulting from the 1907 Hague Conference, and of course all the Geneva Conventions would apply. And that also includes other specific agreements listed here that have a more naval warfare focus, such as the Oxford Manual of Naval Warfare, and more recently the San Remo Manual on International Law applicable to armed conflicts at sea, and various other agreements and treaties which help inform this area of law and help states to understand what is allowed and what isn't allowed in terms of when they can engage in acts of war, or when they are engaging in acts of war, what is permitted and what isn't, and the sort of obligations they have to enemy states or neutral states and so on. So one concept which I picked out, which I thought was quite interesting, is a concept which is known in the sort of historic sort of customary law of the sea as free ships, free goods. It was a 17th century principle, which has become more codified in recent times and was included in the 1856 Paris Declaration. And what this says is that except for contraband of war, any enemy goods travelling aboard a neutral ship are not to be subject to acts of aggression. So what we're saying here is that if the ship is neutral and it's flagged to a neutral state, then ultimately the ship should not be a target, um, except for exactly when that ship is carrying contraband of war. Now, this issue of contraband of war is interesting, and what it's saying is that even targets that are effectively civilian targets or neutral targets would not be obviously the subject of aggressive acts during wartime, but when they are carrying contraband of war or perhaps munitions or something, then of course they may be included as part of the war effort and may become a valid target. So that's what happened, for example, in the RMS Lusitania case. Now, of course, you all know my fascination with shipwrecks, and that includes the Lusitania wreck, which is off the coast of Ireland. So this was a transatlantic passenger liner which was travelling back from New York to Liverpool in 1915, and it was struck by a German U-boat, as I say, just off the coast of Ireland. And it was hit with a single torpedo, but it really struck the ship in quite a severe way, and the ship sank very quickly with the loss of 1,198 passengers and crew. So it was a very shocking incident. It was a huge international event, and it's regarded as the moment that brought America into the First World War because there were American passengers on board. And of course, there was a controversy about the fact that Germany had targeted what was effectively a civilian ship. These were all just passengers travelling from New York to Liverpool on going about their daily business, and they were targeted by a German U-boat. So obviously, this was a huge controversy and shock. And it's not the only case where this has happened. There have been other cases of course, in all times of war where civilian targets have been hit. But this was a particularly significant event. And Germany defended itself, saying that, in fact, the Lusitania was carrying in her cargo lots of ammunition and various other things that were being brought over to Europe for the Allied war effort. It's a allegation which does appear to be certainly possible based on records, and I think that subsequent searches of the wreck since have also shown that this could be a valid argument. But still, you would say, does that necessarily justify the intentional targeting of a ship which clearly was carrying a lot of passengers? That still remains a controversial question. So, one thing to bear in mind, as we mentioned, is that maritime security and military operations are quite closely interlinked. Now, we did a lot on maritime security when we covered crime and piracy and the law of the sea, and what we'll see here is that there's quite a crossover. And this is because, as we mentioned in crime and piracy, that a lot of enforcement and arrests of vessels and so on and inspections need to be carried out by government vessels. And that's usually naval vessels or specific police or coast guard units. But very often their operations can be very similar or interlinked. You can often find military vessels engaged in security enforcement in terms of the ocean. So very often, therefore, research into military activities and research into maritime security can often blend or move over from one to the other. And this is because you would often see warships or naval auxiliary vessels or military aircraft, or as I say, Coast Guard units and so on, as well, being involved in enforcement against things like pollution law or undertaking hot pursuit or engaging in the right to visit or seizing pirate ships or arresting illegal fishers and so on. So there's lots of activities that military vessels may be engaging in, which also are security sort of related. So sovereign immunity, this is an important concept into international law generally, not just the law of the sea. It applies in all international law, for example, to foreign embassies, or to diplomats who might be travelling, or other things that may be representatives of the state. They are effectively embody the state, if you like, the sovereign state, and as such, they're not subject to the sort of jurisdiction of national courts, of a foreign national court. Instead, they're subject to their own state's jurisdiction, and matters are resolved between sort of diplomatic negotiations between states. So they have an immunity from suit, and it is for comity and for principles of international diplomacy to govern interstate relations with regard to those particular people or properties and so on. So this, for example, in the law of the sea context, dates back to the schooner exchange, which was back in 1812, and this related to the schooner. I don't believe this is the schooner on the right-hand side, but I wanted to find a schooner that looked similar to what the exchange would have looked like. And it was one called the exchange, which was seized and converted by Napoleon, and it was converted into use for the French Navy, and it was rebranded and put into French service. Later on, that same vessel, so it was now operating under the French Navy and under the French, sovereign umbrella. Later on, that vessel docked into Philadelphia in America, and the original legal owners, who were American, brought a legal action claiming that it was stolen, and they tried to, commence a case, arrest against the vessel. And the court case proceeded to assess whether they would have jurisdiction. And what it was decided by the US Supreme Court is that because the ship represented, again, it was the sort of arm of the state, of the French state in this case, it wasn't for an American court to have jurisdiction over it. Rather, it was between the American and French governments to negotiate the treatment of the vessel. So it was sort of immune from jurisdiction of the court and subject exclusively to the jurisdiction of the French state. So it said that a warship constitutes part of the military force of her nation, acts under the immediate and direct command of the sovereign, and is employed by him in national objects. He has many and powerful motives for preventing those objects from being defeated by interference of a foreign state. Such interference cannot take place without affecting his power and his dignity. The implied license, therefore, may reasonably be construed as constraining an exemption from the jurisdiction of the sovereign. When referring to he and him, I think it's referring to the state in this case. So, the state has these rights, and they cannot expect. It wouldn't be fair to have, these people carrying out duties on behalf of the state who would be subject to the whims of a foreign court. So this has become established in international law. For example, a recent case in the law of the sea was the ARA Libertad with Argentina versus Ghana, where this was where they got provisional measures and argued successfully for the release of a vessel based on it being subject to sovereign immunity. And it's also found in various international agreements. For example, the United Nations Convention on Jurisdictional Immunities of States and Their Property, Article 16, although it wasn't widely ratified, it was widely respected, and many of its provisions have been widely respected, and certainly in customary international law, a lot of the practices reflect this movement of, recognition of sovereign immunity. So this therefore feeds into the Law of the Sea Convention with a number of important articles, but one in particular is Article 32, which says that except for the exceptions in Articles 30 and 31, nothing in this convention affects the immunities of warships and other government ships operated for non-commercial purposes. So it isn't stating that sovereign immunity exists, but what it's saying is that any existing international law or customary international law on the rules of sovereign immunity are not to be affected or prejudiced by the Law of the Sea Convention. So effectively, it is maintaining international law with regards to sovereign immunity and showing respect for that principle. The exceptions to which it refers, interestingly, are in the Territorial Sea, and it's in the Territorial Sea that the conflict between sovereign immunity and the territorial state are particularly in tension, of course, because you're effectively inside a state's territory. You're inside another state's exclusive sovereignty, but you will also have sovereign immunity. So there is a tension there that naturally exists. And what it says is, if the vessel, which is under sovereign immunity, doesn't follow with the sort of laws of the coastal state and refuses any sort of reasonable request for compliance, then the coastal state may require and is allowed to require that vessel to leave, which kind of makes sense. You have to follow the law. You have to respect the territorial state's laws, and if you don't do so, then it's fair that you can be asked to leave. And that also includes in Article 31 paying any compensation for any loss caused by such breach of the law. So while it is subject to the sovereign immunity of the flag state, of course, the flag state may be required to compensate the coastal state or require its vessel to leave the area if, of course, it's not complying with coastal state law. However, that's just with regards to the territorial sea. Nothing else in the convention prevents sovereign immunity. So it says that under Article 95, warships on the high seas have complete immunity from the jurisdiction of any state other than the flag state. So again, it's the flag state that has the sovereign immunity. The vessel belongs to that state. It's representative of that state. And it has complete immunity from jurisdiction of any other state. Now, in this context, it says on the high seas, and something that's confusing in the Law of the Sea Convention is sometimes when we're referring to the high seas, we're also referring to the exclusive economic zone, because we have to remember that the exclusive economic zone is a sui generis zone, and really what it is a bundle of rights and obligations that exist in parallel with the high seas regime. So the high seas regime and the freedom of navigation and everything continue to subsist beyond the territorial sea, but there are certain zones like the contiguous zone and the exclusive economic zone and the continental shelf which have additional obligations and rights which apply beyond that. So effectively, when we're saying the high seas in this context, we're also referring to the exclusive economic zone, except for where the exclusive economic zone rules amend those rights or obligations. It says Article 95 that it refers to warships. We also have Article 96, which says the same to any ship owned or operated by a state and used only on government non-commercial service. And this sort of these sorts of two definitions seem to be running throughout the Law of the Sea Convention and international law generally, where we talk about warships, but we also talk about vessels owned and operated by the government on non-commercial service. It's almost like there's two definitions, but they often point to the same thing, because obviously warships are owned and operated by a state and used only on government non-commercial service. But I think the additional definition is often used to obviously capture those other vessels that might not be naval units necessarily, but represent similar sort of responsibility in terms of maritime security or public enforcement, like Coast Guard units or other sort of police units and so on. Similarly, therefore, environmental crimes in the EEZ, we said that the sovereign immunity continues to apply, except for the extent to the extent that the EEZ regime changes things. Then what it says here is basically that any of the rules with regard to marine pollution. So remember, under Part 12 of the Law of the Sea Convention, we dealt with a lot about marine pollution and the protection and preservation of the marine environment. What it says there is effectively that none of those rules impact a state's sovereign immunity, i.e. a state continues to have sovereign immunity. So you can see that with Article 95 and 96 above, shows that beyond the territorial sea, effectively, sovereign immunity does stand strong. So then the question, we mentioned before that there are this definition of warship and vessels operated on government service. What are we talking about? Well, Article 29 does define what a warship is, and it says that a warship means a ship belonging to the armed forces of a state, bearing the external marks distinguishing such ships of its nationality, under the command of an officer duly commissioned by the government of that state, and whose name appears in the appropriate service list or equivalent, and manned by a crew which is under regular armed forces discipline. So there's a few elements to that definition, but you can see from that, what are we talking about? Well, we're talking about naval vessels, naval units, naval craft, and so on. But of course, then we have the other definitions throughout the convention, which often refer to vessels which are owned or operated by a state and used only on government non-commercial service. This isn't really defined anywhere, But as I mentioned before, generally this is going to refer to your constabulary vessels or auxiliary naval units or your coast guard or police units and so on. So effectively, they are employed by the state full time. They're not engaging in commercial service, but actually engaging in state activities under the arm of the state. So now we're going to look at military activities across maritime zones and the difficulty with knowing what is permitted in different zones, and particularly the sort of tensions between states as they try to display their military power or to show that they reject another state's interpretation of the law of the sea by engaging in military activities which purposefully sort of reject another state's interpretation. So, as I mentioned, what often happens is that increasingly states, well, not increasingly, it has always happened, I suppose, that states will carry out military exercises and undertake activities that will either display a sort of sense of military power and domination, was one way of interpreting it. But of course, really, what they're trying to do, allegedly, is to assert their view on what the law of the sea is and to make sure that the law of the sea is properly complied with and followed, and therefore to challenge any state's excessive maritime claims, i.e., states who interpret the law of the sea in a way that is excessive and not in line with the wider custom, but perhaps is an interpretation which is much more favourable to that state. So, for example, this might be undertaking this might be, well, for example, a coastal state claiming a maritime zone or a boundary which is beyond the sort of rules given in UNCLOS or international law, or, for example, imposing obligations or rules inside different maritime zones. We've talked about creeping jurisdiction and creeping coastal state rights. Well, it might be that a coastal state is imposing certain laws in a certain maritime zone, and that a flag state wants to reject that interpretation and therefore is purposefully carrying out activities which are in breach of that interpretation. So one well-known one, for example, is where a coastal state requires prior notification from a warship before it goes through a territorial sea and undertakes innocent passage. So here's some examples. I mean, there's loads, but here's some well-known ones or some very current ones where there has been, an increasing tension and the use of military exercises, which are effectively a form of addressing excessive maritime claims. A well-known one, of course, is the South China Sea. This is the most current and most important one at the moment in terms of the international development. And as many of you will know, the South China Sea is currently going through quite a complex and difficult period of interstate conflict, I would say, and disagreement regarding interpretation of the law of the sea, interpretation of different states' respective boundaries and exclusive economic zones and territorial waters and so on. And there's various states involved. These are the main 7 states, which is China, Philippines, Taiwan, Brunei, Malaysia, Indonesia, and Vietnam. They are the sort of geographically located states in the area. But of course, other states have been getting involved too, supporting their allies or, making sure that the rules are interpreted correctly. Most notably, the United States, of course, but other Western powers as well have been becoming increasingly involved and embroiled in the South China Sea dispute. There's also the East China Sea, again with other states getting involved, but the main 2 sort of states in conflict in that case are Japan and China, disagreeing about boundaries and features in the East China Sea. Then you've got the Gulf of Sidra, which is off Libya in the north coast of Africa. This was historically a place of particular contest between the United States and Libya, with Libya having drawn a huge straight baseline across the whole Gulf of 300 nautical miles long, which is, well, as far as anyone can tell, not in any shape or form in line with the international rules of maritime boundary delimitation. There's nothing in the UN Convention that supports their interpretation, but they are effectively saying that that entire space is internal waters and belongs to Libya's internal regime, and that has led to tensions between the United States and Libya. Of course, we've got the Arctic, where there's increasing militarization and build-up of different forces, and of course different territorial claims from Russia, America, and Canada, and so on, as well as Northern European states such as Scandinavian states and so on. So there is this building tension in the Arctic, and one of the key flashpoints, hot points at the moment is the Northwest Passage through Canada, which is increasingly opening up because of melting ice. And the question is whether that is a international strait or some other thing. And Canada is arguing that it is part of Canada's internal waters. And of course, another one we've referred to already on this course, but which is very current at the moment, is the Black Sea and the growing tension between Russia and Ukraine in terms of access and through the Kerch Strait because of Russia's illegal annexation of the Crimea and the difficulties around that, and the sort of excessive maritime claims of one state over the other in that region. So FON Ops, freedom of navigation operations, have become the current strategy for a lot of states to resolve the South China Sea dispute. Whether it's working or not is another matter, but the idea is to make sure that it's said before. We've said before that consistent objectors to the law of the sea could effectively prevent a law from becoming customary practice. So it's important for states to ensure that an interpretation of the law carried out by one state is not respected or accepted by other states, and that other states aren't found to be acquiescing in that interpretation, but in fact to almost intentionally fly in the face of that interpretation and to counter it with what they believe to be the actual interpretation of the law of the sea. And that's been what's been carried out in the South China Sea, particularly by the United States. Against China, because China has adopted this excessive what's called the 9-dash line. Just getting my pen. So it's this 9-dash line here is China's interpretation of its rights over the South China Sea. And there's lots of ambiguity as to how China has alleged this ownership, but it just says it does own all of that. It just makes the clear statement that it has historical rights, and particularly what are the key points is the Spratly Islands and the Paracel Islands here. So these are the key island groups. Most of them just atolls and reefs or rocks. They're not really necessarily important islands in terms of the economic resources on the island, but they are useful in a number of other ways. They're often being built up for certain purposes, for perhaps military bases and so on. And also, if you have the island, you can have the territorial sea around it. And potentially, if it's a habitable island, so if it's a rock, you can have a territorial sea. But if it's a habitable island, you might have, of course, a larger claim to the entire exclusive economic zone around that island. So there is a dispute over ownership of these islands, and in many cases, it's almost impossible to resolve because states are alleging their ownership based on historic usage. Well, of course, if you go back over the last many hundreds of years, even thousands of years, they've been used by all sorts of countries and nations all around this region, and it's very difficult to establish any firm ownership over the islands. And in reality, it seems to be that the islands have been used for a number of purposes over the years. But this has, of course, led to quite a lot of tension and disputes. So, of course, recently in the news, you might have seen the Philippines versus China arbitration, and this related particularly to the Spratly Island group here and Philippines' sort of interpretation of their exclusive economic zone, which includes a large part of this Spratly Island group. But China's own interpretation, of course, is that the Spratly Island group belongs to them, and all of this is under Chinese jurisdiction. Now, of course, this is important for a number of reasons. Not only is oil a major sort of area of economic potential in this region, but of course, fishing rights as well are economically significant. And then on top of that, of course, this is a hugely important international navigational route for commercial trade and so on, with billions of pounds worth of trade coming through this region. So there's an element of making sure that this corridor is also kept open for international trade. So there's all sorts of tensions as to why states want to own these island groups and assert their jurisdiction. And as I say, there's also the need to build up military in the region as well. So that was the reason that the Philippines brought a legal case against China, trying to establish that China didn't have jurisdiction over these islands effectively. So what we've had increasingly is a number of states from outside the region in particular, so the United States, Australia, Japan, and recently Britain and France as well, sending in military vessels to undertake FON Ops, freedom of navigation operations in the South China Sea, to assert their rejection effectively of the Chinese interpretation of international law. And to make clear that they believe, perhaps rightly so, that China are not following international rules and are not interpreting the UN Convention on the Law of the Sea or customary international law correctly in terms of their claims over the region. So what we see, for example, some of the activities are that warships are undertaking passage which is obviously not innocent in the territorial sea of an island which is determined to be not a rock or an island, but instead a low tide elevation. So to explain that, if you remember, we talked about innocent passage in the territorial sea. You can travel through a territorial sea, provided that you are you're traveling through, you're going from one point to the other, and you're doing so innocently. You're not prejudicing the interests or the security of the coastal states. You're not engaging in any activities which could be problematic, but you are just going through and not causing any threat. That's generally permitted. But of course, certain activities which are well known to be the activities that wouldn't be innocent, for example, would be undertaking perhaps a military exercise, like traveling in a zigzag formation, or launching helicopters, or launching craft, or having weapons visible on the deck, and so on and so forth. So certain things which are known to be a more threatening act, rather than just passing through as a military vessel with everything um, stowed away. These would be acts which would be non-innocent and in a sense would effectively be a breach of the innocent passage rule. And what we find is that warships are doing that within what is effectively 12 nautical miles of islands which have been found to be low tide elevations. So in the recent Philippines and China arbitration case, for example, the court determined itself to have jurisdiction over the interpretation of international law with regards to um, whether they were islands, habitable islands, or whether they were rocks, or whether they formed what are low tide elevations. Now, rocks and islands have a territorial sea, so they have the rules on innocent passage up to 12 nautical miles. But if you remember back to our session on boundaries, low tide elevations do not have a territorial sea. They're significant only because they extend the existing territorial sea of the mainland or the island, another island. So they are effectively outlying rocks which are visible at low tide, but which are submerged at high tide. So they're not proper islands because they are submerged at high tide, but they can extend the baseline claim of the mainland or surrounding island. Um, so because of that, they don't have their own territorial waters and therefore their own territorial sea, and therefore warships traveling through, engaging in acts that are not innocent, effectively would be rejecting the interpretation that they are an island and instead arguing that they are a low tide elevation. And there are a number of islands in the Spratly group and in the Paracel Island group, which are found to be likely to be low tide elevations rather than um, rocks or islands, and particularly in the Philippines v China arbitration, there are a number of islands that were found to be LTEs, and these are islands that the United States and other vessels have intentionally undertaken military exercises within 12 nautical miles of. Um, Another one is, which is a bit easier to explain, is that China imposes an obligation for any warships passing through the territorial sea to require prior authorization from the coastal state. So before you pass through, you need to ask the coastal state's authorities, we're going to pass through in a warship. Is it okay if we have permission to pass from this place to this place? And the coastal state authorities can reject that request or give permission. But most states recognise, and that this isn't a part of customary international law. Nowhere in history is is this widely accepted, and many many flag states and coastal states reject this interpretation. Um, Although there are a number of states going the other way who still uphold these sorts of rules. So it's a rejection of that particular rule, of that particular creeping jurisdiction over the territorial sea. And what happens is warships travel through without getting any prior authorization. So a lot of American warships, for example, are traveling through Chinese territorial seas in the South China Sea, but not requesting prior authorization. Um, and another one is undertaking activities in the exclusive economic zone. Different states interpret what states can and can't do in the exclusive economic zone differently, but a number of coastal states, including China, do not allow foreign states to undertake military exercises or activities in the coastal state's exclusive economic zone. So another state inside your exclusive economic zone is not allowed to undertake military exercises. But most states reject this interpretation. They believe that such activities fall under the freedom of navigation. There's no rejection of this in international law. There's nothing that has ever said that you cannot undertake military exercises in another state's exclusive economic zone, except for where it's obviously, clearly prejudicial to the interests of that state. So in this sense, it's widely accepted to be permitted, but China in this case rejects this interpretation. So you will often find, again, American vessels undertaking military exercises in the exclusive economic zone, which again rejects that interpretation. So another thing to think about, we mentioned at the beginning about innocent passage, and we've previously talked about transit passage through international straits. So when we talk about international straits, if you remember, we particularly talk about what falls under Part 3 of the UN Convention on the Law of the Sea, and refers to travel, parts of the sea where you're traveling between one part of the high seas or an exclusive economic zone and another part of the high seas or an exclusive economic zone. So they are effectively important passageways for international communication and international trade. And we mentioned some examples, for example, like the port of Gibraltar and passing into the Mediterranean, or the Dover-Calais sort of English Channel route, which is a passageway, of course, up into the Northeast Atlantic and so on. So these are important passageways where you are allowed a specific regime of transit passage rather than innocent passage, which is slightly different to innocent passage. And we've previously mentioned about this difference between them. But of course, there is some slight differences. They're very similar, these two regimes, innocent passage and transit passage, but there are some slight differences. So I won't go through it all, but for example, under Article 18, innocent passage means traversing the sea in a manner which is continuous and expeditious, and which is not prejudicial to the good order or security of the coastal state, as is said under Article 19. And then Article 19.2 lists some of these sort of prejudicial acts, and it's very clear looking at it the sorts of activities which would be prejudicial to innocent passage. For example, using any weapons, undertaking any act which is, threatening to the coastal state, gathering information or spying on the coastal state, launching, landing or taking on board any aircraft or military devices, interference with communication systems, or any other activity not having a direct bearing on passage. So, we talked about illegal fishing and other sorts of activities. And what's also important is Article 20, which specifically requires that submarines and other underwater vehicles are required to navigate on the surface and to show their flag. So you cannot pass through under the surface if you are a submarine vessel. Transit passage, conversely, is slightly different. It says it means freedom of navigation and overflight solely for the purpose of continuous and expeditious transit of the strait. So there's a slightly different definition there, but what we're talking about is making sure that travel is continuous and expeditious. and there is some discussion of what that means in the surrounding articles. But what's important to point out is that it says navigation and overflight. So whereas you don't have innocent passage in the airspace above the ocean in the territory in terms of innocent passage, you do have it in international straits. So you can pass through as an aircraft if you're flying in the airspace above through this international passageway in terms of transit passage. So that's an important point. And there are some rules, as I say, Article 39, which would sort of talk about what we're talking about in terms of continuous and expeditious travel, and it's proceeding without delay, refraining from any threat or use of force in a manner which is not in accordance with international law, and refraining from any activities other than those incident to the normal modes of continuous and expeditious transit. Now, this has been widely interpreted and agreed to say that this allows submarines, in this case, to travel under the surface, because the normal mode of travel for a submarine is under the surface. So this is an important difference between them again. So we've got on the innocent passage side of things, you need to make sure that submarines are traveling on the surface with their flag visible, and that warships are, everything is effectively stowed, and they are being very clearly non-threatening as they pass through, being very open and transparent about their activities. But transit passage is a bit more about, expeditious movement. So you can travel under the surface, and you can travel in any sort of way that you normally would as a warship, but you've got to just do so in a way that you are traveling through and not stopping. But you can see where there is room for some conflicting understanding between these two principles. So we mentioned earlier that China, for example, has rejected the United States interpretation of the law of the sea, which allows a flag state to carry out military exercises in another state's exclusive economic zone. And they're not alone in that. There are other states that have rejected this interpretation. But most states, so we've got here the argument from most states, which is that they maintain that the freedom of navigation concept, which if you remember, we said applies to the high seas, and that therefore includes the exclusive economic zone, where it doesn't prejudice the rights and obligations which come under the exclusive economic zone regime. That most states maintain that this freedom of navigation includes the undertaking of military exercises, obviously carrying out these exercises with due regard to the interests of the coastal state and not prejudicing their interests. They also point out that Article 58, particularly under the Law of the Sea Convention, which is important on this, says that effectively states have the freedom to use the exclusive economic zone for all other internationally lawful uses of the sea. So it's saying effectively, if it's not outlawed by the exclusive economic zone regime, then you can assume that the high seas regime applies, and that any sort of lawful use of the high seas would apply in terms of a lawful use of the exclusive economic zone. Contrasting this, though, many states have rejected and consistently maintained their rejection of this interpretation, and upon signing the Law of the Sea Convention, actually, expressly entered this reservation, even though it wasn't permitted under the convention to enter this reservation. They made a declaration that they will not accept military activities being undertaken in the exclusive economic zone. So they're not alone. There are a lot of states that have this interpretation, but you can see there's a tension here. And as mentioned earlier, this has led to a number of states carrying out activities which would be military exercises that clearly breach the view of these states that want to see the exclusive economic zone have a thicker and firmer number of rules that are linked to the coastal states. So again, we're talking about creeping jurisdiction. We're talking about the tension between coastal states and flag states, in particularly the exclusive economic zone. But these states want to maintain the freedom of navigation for flag states, and to prevent coastal states from exerting effectively full jurisdictional control over the exclusive economic zone. So they carry out reconnaissance and sort of any sort of information gathering and so on, which isn't clearly an act of aggression, but which is just generally carrying out a form of military exercise in the exclusive economic zone, as well as other forms of military exercises and drills and so on. So, as mentioned, therefore, there is this different interpretation as to whether you can carry out military exercises in the exclusive economic zone. But this also feeds into spying and reconnaissance and information gathering, and has led to, again, further tensions between states in the exclusive economic zone. For example, Japan protested against Chinese research vessels believed to be gathering intelligence in the Japanese exclusive economic zone, and also attacked and sunk a North Korean vessel back in 2001, which it also believed was spying and gathering information. And vice versa, that China has sought to restrain the presence of US surveillance vessels and aircraft over its own exclusive economic zone. So you can see that there's this tension, and coastal states are clearly nervous when they see vessels undertaking what they believe to be surveillance or effectively spying or recording of navigational activities and so on, or even coastal state activities out in the exclusive economic zone. So there is this tension, at what point does it become prejudicial to the coastal state interests? But largely, the freedom of navigation rules would suggest that military vessels are free to use the exclusive economic zone, you know, for general purposes, and that includes military exercises. So whether you can undertake spying and reconnaissance is wrapped up in this interpretation of military activities in the exclusive economic zone. I've mentioned previously that there is uncertainty about hacking into submarine cables. Now, I don't know um, in the ins and outs of whether it's feasible or the technological capacity to do so. But of course, as you are aware, the entire world now is increasingly interlinked by submarine cables, which are effectively providing all our broadband and communication and so on. And a lot of data and information is being passed through those cables. Well, if it would be possible to hack into those cables and unscramble the codes, you might be able to find out a lot of information, or, of course, you might be able to interfere with that information or even cut that information from reaching the state. And it could be a form of international terrorism or a form of cyber aggression, or, of course, it could be some element of espionage in terms of gathering information. So the question is, to what extent can states carry this out on submarine cables? What can they do in terms of interference with submarine cables? Well, it's clear, again, territorial sea, you're effectively inside that state. So any information, intelligence gathering or interference with systems of communication, as under Article 19, would be prejudicial to innocent passage. And under Article 21, coastal states are able to enforce regulation to protect their cables and so on and so forth. So any such activities where you might be interfering with cables in the territorial sea would obviously be a breach of the coastal state's laws and could subject you to coastal state action. However, beyond the territorial sea, again, we're looking at the exclusive economic zone and the high seas in parallel. And Article 113 is the only article that really deals with interference with cables, and it only prohibits negligent or willful breaking or injury to cables. So it's quite interesting to note that there's no actual obligations or rules in terms of you know, interference with those cables that might not actually be a willful or negligent breaking or injury to the cables. So that's an interesting one in terms of the, ties in again here in terms of spying and reconnaissance in the exclusive economic zone and the extent to which you can undertake spying or reconnaissance, perhaps observing data that's passing through these cables. So then you look at all this wrapped up, of course, with the high seas regime as well, which under Article 88 and 141. So 88 is under the high seas regime, 141 is under the regime for the deep sea bed for the area. These are to be reserved exclusively for peaceful purposes. Again, so we mentioned that at the beginning of the presentation. What do we mean by peaceful purposes? Well, effectively not undertaking acts of aggression and following the international rules on naval warfare and so on. But also it tied in with the regime for marine scientific research, and this includes effectively an agreement that research is to be carried out for peaceful purposes, where it's carried out in the high seas or in the exclusive economic zone of another state. So again, that kind of is wrapped up in this research you might be undertaking or interference surveillance you might be undertaking in the exclusive economic zone. So what does all this mean together? I mean, as with all these things, who knows? I mean, the law of the sea, although it's something that is thousands of years old, there's still a lot more to be decided and a lot more to be um, determined in future years, perhaps for future cases and future international agreements and future disputes. So we've got a long way to go yet until we understand really the sort of substantive rules on spying and reconnaissance in the exclusive economic zone, and what sort of research you can take out and where that all fits in with the different regimes as they all overlap and interlink. Okay, so finally, just to mention a little bit about militarization. We've mentioned it a couple of times in this lecture so far. We're not strictly talking about law of the sea here. I mean, sometimes a lot of militarization is about activities happening on land. But what we're talking about is strategically important regions or areas in the ocean where states are increasingly sort of deploying military units or building up a military presence so as to effectively assert their claims or assert their ownership in different regions. So it does kind of fit in with the law of the sea because often these are island groups or sort of polar regions, and it's where states are increasingly showing their sort of disagreement by deploying different military units. So this is Fiery Reef in the South China Sea. It was actually a low tide elevation. So we mentioned earlier that it doesn't have the right to a territorial sea and so on and so forth. But through land reclamation, it's been built up by China, and it's now a military port and has an airstrip and everything like that. So this is an example of this increasing militarization of a significant region in the ocean where China are trying to assert their ownership through sort of military power effectively. But it goes both ways. This is a US air base on Diego Garcia Island, which is in the Chagos Island group, which belongs to Mauritius, but which was effectively appropriated by the British government by kicking out the Chagos Islanders and offering it to America to be used for an airbase. So it's been built up as a military base for America, and the islanders were effectively sent away and sent back to the UK to make an unpleasant life there. So as you may have seen, this was the subject of a recent arbitration case where the United Kingdom government was unsuccessful, and the Chagos Island group has had to be handed back to its original inhabitants. So obviously the future of the military base and so on and so forth is obviously in some doubt. But it's again an example of militarization of island groups and a build-up of military presence in regions of the ocean, particularly in some of these sort of far-off regions where it's difficult to perhaps build up a military power. And here is an example of militarization in the Arctic. We mentioned earlier that different states have different competing territorial claims in the Arctic. So we're often seeing increasing military drills or deployment of naval vessels and so on to the region. Again, it's to kind of assert territorial claims, assert their status as owners of regions in the Arctic. And, you know, whether these are going to lead again to future tensions, we shall see. But it's certainly a case of building up this tension and this rejection of other states' excessive maritime claims and so on. So thank you. That was all we had in the presentation, and I look forward to seeing you all next week. But I hope you found this useful in terms of giving you an introduction to some of the current issues going on in terms of military exercises in the ocean. Thank you.